Welcome to another ViewMedi session. I'm your host, Jeff Segal. I'm both a physician and an attorney. I was a board certified neurosurgeon for approximately a decade, then in biotech, and now I'm a lawyer. One of the organizations I founded is Medical Justice, focused on keeping doctors from being sued for frivolous reasons. We also assist physicians with all types of medical legal conflicts, including issues with credentialing committees, Board of Medicine complaints, assaults on online reputation, and the National Practitioner Data Bank. I'm also a partner at the firm Dado. And without further ado, let's dive in. Covering your own assets. Should I get my own professional liability policy in addition to what my hospital provides? Now, if you are working as a W-2 employee for an institution, presumably in your employment agreement, you would have negotiated for and received med-mal coverage. It's usually part of the benefits package. I wouldn't even call it a benefit. I think it's a must-have. In fact, if you don't have professional liability coverage as a W-2 employee of a healthcare institution, I would just find another institution to work at. But really, the question is, do you need more? Is that sufficient? Is it enough? So, part of the challenge is that the policy that you are given to doesn't always think of you first. It may be thinking of the institution first. So, I mean, is that really a surprise? I mean, you're getting free professional liability coverage. Yes, the institution is going to make sure that its needs are met, but certainly if you are sued, they're going to be sued. So they want to make sure you do have coverage. But the key initial analysis is identifying what do you have? What are you being protected for? And where are there gaps? And having another policy, a separate policy, could actually fill in some of those gaps. All right, so if you're part of a large healthcare organization, normally it's a cookie cutter policy. They often do not negotiate for the various details and nuances of what is being provided. But they do vary. Sometimes it looks like they're doctor friendly. In fact, I've even seen it where the doctor may even have the right to consent to settlement, but more often than not, they seem to prioritize minimizing the hospital's liability over your specific preferences. And the detail that most doctors love to have in terms of their own policy is a consent to settle. What is a consent to settle policy? Well, it says that before the professional liability carrier can write a check to a patient slash plaintiff, they need your written authorization. So if you do not have this consent to settle clause, they'll defend you, but at some point they may make a business decision to write that check, whether or not you think that's a good idea. So if you've got a consent to settle clause in your institutional policy, that's wonderful. I would say that is more unusual than typical. If you have your own policy, you typically do have the ability to consent to settle. That's a very common clause, but if you are a W-2 employee for the hospital, their policy is likely to trump unless you're on your way out the door, you've already left, and you've said, I will use my own policy because I had two policies. Very unusual, very atypical, but I'm mentioning this for the sake of completeness. All right. So I got a little bit ahead of myself describing what a consent to settle is. Yes, without that provision in your policy, the hospital can pretty much do what it wants. And one of the things that we often see is that you've worked for an institution for 5 years, you've decided to leave. 2 years later, you learn you're being sued, but you don't even work for that institution any longer. You don't even live in that same state. And everybody else who's named in that lawsuit still works for the institution. Is it possible, even likely, that the institution's insurance company will throw you under the bus, settle in your name, and let everyone off the hook? Yeah, that is possible. You're not an audience that they need to satisfy any longer. you're long gone, you're not part of the fold. And so based on the provision in the policy agreement, they can settle that case. So one of the benefits to an aggressive or the lack of the consent, and this is unusual because typically I don't think there are many benefits, but there actually is a benefit, and I've heard this touted as a benefit to joining as a W-2 employee and having no access to settling. Is that early on, if a plaintiff attorney calls the hospital and says, we're going to sue the institution, and the hospital's attorney jumps on board and says, you know what, we've done our own internal investigation. We think that a payout makes sense. We'll just negotiate the details. But the quid pro quo is that the hospital is going to settle in its own name. The lawyer will understand that if they want an easy check, they need to negotiate strictly with the hospital. They haven't named any individual providers as people they may sue. So there's no settlement in the name of a doctor. The settlement is in the name of the institution. So what's the benefit of that? Well, if there's no payment in your name, then there's no reporting, at least in theory, to the data bank. Now, the data bank has tried to um, cut out what we call the corporate loophole, but for the most part, it's established, meaning that if a lawsuit hasn't been filed at that point, and it looks like they're negotiating for a settlement, then the hospital is within its rights to make the payout and indemnify everyone, saying that there's no opportunity for the plaintiff to sue any of its employees because the matter's already been settled. So that's the good news. The downside with an absent consent to settle provision is that you have little control. I've seen policies where you can participate meaningfully in defense, which is nice to have. But at the end of the day, with the binary choice of settling or no settling, if you don't have a consent to settle provision, you lose that control. All right, so some have asked me, Jeff, what do I think about having a separate policy? And the answer is it depends, because not 100% of your activities may be at the institution that is employing you. It could be that you do stuff off the clock. So, for example, if you are taking care of a friend and this morphs into negligence and a lawsuit, not a great outcome, then your hospital policy is almost certainly not going to cover you. That would be excluded. If you're moonlighting, you would likely need a different policy to cover the moonlighting. Now, presumably the institution that hired you will provide you coverage for any actions or any activities you provide in service of that contract, but you need to make sure. I've seen moonlighting contracts where it says you, the doctor, as an independent contractor, need your own professional liability policy. So just remember that your day job policy, the one that the healthcare institution provides you, will not cover you for off the clock activities. This includes even, um, uh, I guess, actions related to curbside consults. Typically, a pure curbside consult would not lead to litigation, but if the curbside consult bleeds into establishing a doctor-patient relationship, and remember, a doctor-patient relationship is established when a patient reasonably believes that such a relationship has been formed. That's very broad. You could get snared into a problem without having any coverage. So sometimes it does make sense to have another broad coverage, particularly if you're engaged in other activities outside of your day job. All right, so what about if you leave the institution, you're W-2 employee? There are different types of coverage, and the question is, do you need tail coverage? Tail coverage addresses lawsuits that are filed after you leave. So the vast majority of policies in the United States are sold under what is called claims made. That means that you need to have continuous coverage between the date that you took care of this patient and a date a lawsuit is filed or a claim is made. And if it turns out that you were sued down the road meaning that you haven't continued to make premium payments to keep it up to date, you need to have purchased tail coverage. Tail coverage addresses the infinite premium payments down the road. In a sense, tail coverage is a single or maybe a payout over time to keep you up to date and covered if the legal claim is made after you leave, after you stop making your traditional payments. So a claims made policy would require tail coverage, or they call it extended reporting endorsement. That's a fancier name for tail after you leave. Now, the less common policy is called occurrence. Occurrence has a tail bundled into it, meaning that if you had an occurrence policy when you took care of the patient, it really doesn't matter when the claim was filed because you're covered. You do not need to purchase tail coverage because hypothetically, tail coverage is bundled into occurrence coverage. Occurrence policies are typically more expensive than a claims made policy. But you should at least know the difference between claims made and occurrence. Now, just because I want to make this as confusing as possible, I'm going to talk about something called a modified claims made policy, which is frequently provided with large institutions, large healthcare institutions, if you're a W-2 employee. Modified claims made functions similar to an occurrence policy, even though it has the language or the wording in their claims made. It does seem to bundle in tail coverage. I would probably ask to make sure whether modified claims made will cover you after you leave, because it's not always clear. Modified claims made is a term of art in the insurance industry, and the policy language will dictate who pays for what and when. So because it has the word claims made, I would ask. What happens if I'm sued after I leave the institution? Is there tail coverage provided? Do I need to worry about that? Get that in writing. So typically, modified claims made means it's similar to occurrence, but because it has the word claims made, you need to understand what precisely is modified. In any event, if you have your own policy, it follows you. You're continuing to make premium payments. It will follow you if you change jobs. All right, one of the important things about tail coverage is trying to figure out who pays for tail coverage. You're a W-2 employee of a healthcare institution. You leave, do they have an obligation to pay for tail coverage? And first, do you have tail coverage bundled in? If you have an occurrence policy, there's nothing to really negotiate. It's already bundled in. Once you leave, any actions that turn into negligence or claims should and will be covered. But if somebody must purchase tail coverage on the way out the door, you want to have this conversation before you join, before day number one. Because if it's silent, it's possible that your employer is counting on you to purchase the tail coverage on the way out the door. Now, you may be able to negotiate this on the way out, particularly if they want you to leave and they're trying to sweeten the deal to get you out the door. But your maximum negotiating posture will be on day one or prior to day one before they have hired you. So get this in writing. Who's going to purchase tail coverage if you have a pure claims made contract? If your contract says nothing about it, state law will often fill in the blank. So for example, in New York, there is case law which suggests that if you're working for a large healthcare institution, it's presumed that they will cover you for any claims that are generated due to your activity there. So what does that mean? It means that with litigation, there's an appellate case which concluded that because the contract was silent on who pays for the tail coverage, that the institution was responsible for paying for it. Now, they had to litigate this, and this was very unnerving to the doctor, who had to pay for his own attorney because it wasn't clear who was responsible for the legal expenses, after the doctor had left. There are other states where, too bad, if it's not in writing, your employer may be off the hook. They may not have any obligation under state law to purchase the tail coverage. So every state is different. If I were you on the way in, I would get this nailed down. Is tail coverage offered? First of all, is tail coverage even needed? If it is needed when you leave, who's going to pay for it? Get that in writing up front. All right, so professional liability coverage addresses malpractice, yes, but it also looks at other things. There are riders with some of the policies that you can purchase on your own that may or may not be covered by the institution. What do I mean by that? So if a hospital is investigating you and you're having to defend your staff membership and privileges, you typically have to pay for a lawyer to do that, or you should pay for a lawyer. If there's a medical board complaint, which turns into an investigation, which turns into potential discipline, and your license is on the line, again, you probably should hire a lawyer to help you. And there are policies that are out there that do pay for the legal expenses, which is great because these can get rather costly. A true medical board complaint that turns into a hearing that you've got to hire a lawyer, you have to you have to hire expert witnesses, can run into the tens of thousands of dollars. In fact, it could run into six figures. So this is typically not included in a bread and butter professional liability policy, but there are riders that will cover these non-malpractice risks. So do I think it's a good idea to have coverage for this? I certainly do. And I think nobody believes that they're ever going to need a lawyer to deal with hospital investigations or medical board complaints. Um, just like nobody really believes they're ever going to get sued until they do. But certainly, many doctors know colleagues who have been sued. They may not know of colleagues who have been investigated by the board or who have been subject to a hospital investigation. So, because it's not front and center, because they're not thinking about it, they may not have this type of coverage. But I'm telling you right now, if you pick up nothing from this webinar, strongly consider getting a standalone policy that addresses medical license defense, and hopefully it covers some of the other ancillary risks, such as Medicare audits, such as hospital investigation and defense. They're generally not that expensive. They're actually pretty cheap compared to what a professional liability policy costs. So for the cost, I think it's pretty good. Many of the policies bundle in $25,000 to $50,000 worth of coverage. That's great. I mean, do I think that's enough? I think you should have more. I mean, if it were me, I'd like to see a minimum of $100,000 on that. All right. So now we're getting into what about a pure professional liability policy? Is it worth getting your own policy? And if you have your own policy, in theory, you can get your own attorney, and you have a seat at the table. Now, remember, if you're still a W-2 employee, continued employment may depend upon you having a joint defense with the institution. But if you've left the institution and you want to make sure that you've got coverage, um, and that you have control over the destiny of the lawsuit, having your own personal policy will allow you to have your own attorney and presumably a seat at the table. So it looks after your interest, not just the hospital's interest. And ideally, I think you'd probably want to coordinate with your employer, so at least there's a coordinated defense, or at least I wouldn't call it a joint defense, but at least you're not working across purposes to one another. I don't think it's ever going to be a replacement for what your employer is providing you. But if you've left the institution and there's a possibility that the institution may be looking to throw someone under the bus, it's a lot easier to throw that individual who has left the institution under the bus and truly protect those who still work there. Am I being paranoid? Yes, I am being a little bit paranoid here. Is it worth the extra cost? I think it's certainly worth the extra cost if you are moonlighting and you need your own policy and you want to fill in the gaps with medical license defense and so on. All right, so your employer supplied coverage may be adequate, but you need to eyeball the employment agreement and see exactly what is covered. And many employment agreements do not spell it out. You're going to have to ask for what is specifically covered, and no less important, what is not covered. So if your priorities diverge from the institution, or more likely, if you change jobs, a personal policy can actually protect your interest. And you can decide whether this makes sense, but you have to first have your contract reviewed, understand state law where you are practicing, and understand your risk profile. It's not for everyone. Some people, like to live dangerously. Other people like to have everything covered. All right. So with that, if you have any questions or comments, you can email me at info@medicaljustice.com. Again, info@medicaljustice.com. And there is a QR code on the bottom right-hand portion of your screen, which can and will set you up for a 15 to 20-minute consultation about any thorny medical legal problem you might be experiencing. That will take you right to our scheduling platform. So, in sum, we've been working on dealing with challenging medical legal conflicts for now close to 25 years. We started off by addressing frivolous lawsuits, but now we have escalated to deal with other challenges, including medical license complaints, Board of Medicine complaints, hospital staff membership and privileging actions, national practitioner data bank reports, as well as assaults on online reputation. So it never ends. We're here for you, and I appreciate your attention. And I'll see you during the next webinar that we perform. Again, the QR code to sign up for a free 15 to 20-minute consultation is on the right hand of your screen.